Welcome to this installment of Clarifying Tax Situations with attorney and CPA David W. Klossing.
Will the spousal privilege protect me in a divorce? Under Pereira versus United States 347 U.S. 1-7, 1954, it was held that the spousal privilege continues only for the duration of the marriage. A divorce removes the bar against one spouse testifying against another. The rationale for the spousal privilege is that the trust and confidence between the spouses should not be betrayed by having one of them be forced to testify against the other. Okay? This policy is designed to foster family stability and thus benefit both the family unit and the public as a whole. So here's a case law example of how a divorce can tear down the protections of the spousal privilege. The example case is U.S. versus Fisher, 36 after 2nd, 75-5269. Fisher attempted to appeal his conviction on 7201 income tax evasion for the years 1967 through 1970. He argued that his wife's testimony against him should have been disqualified and therefore he shouldn't have been convicted of income tax evasion. On appeal, his former wife's testimony was found to be admissible in the criminal tax evasion trial against him. The court found that no spousal privilege existed since husband and wife were divorcing at the time of the testimony, and thus the marriage at that time was all but over. The court went on to cite Peek versus United States 321 Federal 2nd 934 and argued that the husband had waived his spousal privilege by his counsel's failure to object when his wife was first called to the stand.